right, it is that time again. Welcome to Order in the Court on Queen City News Plus. I am Brian Blakely.
And I'm Chief Legal Analyst Khalif Rhodes.
My man, you're looking good today. You get a little bit more bounce in your step. You had a good day in court.
Hey, good day in court. It's a good day when you can go and serve justice to the people of the great state of North Carolina. I feel like I did that today. So, yes, I'm
no further details on that, right?
No more details on that. Just know it was a good day. That's for sure.
All right. You guys know the game around here in Order in the Court. We have three topics that we're going to discuss here with Khalif today. Legal situations and happenings around the country. We're going to start right here in North Carolina. Khalif, as we know, 1 month ago, Irina Zarutzka was stabbed, just a brutal stabbing on the light rail. It's created national headlines here and a lot of political issues. Public safety issues going forward, and a lot of folks are trying to right a lot of the things that have come up over the last a month or so. One of those now legislative leaders in North Carolina want to make it tougher for suspects involved in violent crimes to be released before trial, and that proposal would take oversight away from local magistrates on creating release conditions that includes no longer offering cashless bail. You, my friend here, being a former head magistrate here in Mecklenburg County, have unique insight into a lot of these type of situations. Talk to us a little bit about that.
As the former chief magistrate, I can tell you that there are a number of problems, potholes, and issues with this proposed legislation, modifications, recommendations, amendments to legislations. We try to be everything for everybody in life, and sometimes legislatures, members of the General Assembly, try to create a bill that does everything for everybody. You have this scenario here where this young lady was terribly, brutally killed, and now everyone's trying to rush to find the solution because there had to be a problem, right? And in this scenario, the solution is, first of all, let's blame it on the magistrate, that the magistrate that made the selection was in error, outside of her jurisdiction in terms of what she should have done. And because of this, if she just would have followed the process or the rules, this would have been avoided. But if you look at the facts, that's not exactly what happened. So this individual was arrested on a misuse of 911, given a written promise to appear. I bring that up because that portion, when I say trying to be everyone and have a all-encompassing law, that's listed in here. Misuse of the 911 tape and his written promise to appear. Okay, we want to get rid of being able to use written promise to appear for all cases. Now, think about it. We have folks that are arrested for things like, defecating in public, urinating in public, riding the train improperly, not paying your fare. There are a number of things that you're arrested for. And our statutes require that a judicial official, which a magistrate's a judicial official, a judge, a justice of our court, a Supreme Court, and a magistrate, they're all judicial officials. A judicial official will have to set the least restrictive, not the most, but the least restrictive means when setting conditions for release. So in our state, the least restrictive means is written promise to appear. So what they say, we don't like this scenario, we don't like what happened, we're going to get rid of your ability to use a written promise to appear. So what's next? A unsecured bond. So does that solve the issue? I'm letting the person out regardless. They're not paying anything to get let out. So an unsecured bond is just like a written promise to appear. They only have negative effects if the person doesn't appear. Now, if that person doesn't appear and you have a written promise to appear, all right, that's not good. We don't have anything to hold over them. But if they miss and they have a unsecured bond, now once they're arrested, it will be a secure bond and it will be doubled. But they still didn't pay to leave, so it doesn't make us safer. It doesn't make the community safer by removing this written promise to appear. It's just now taking one of the many things that magistrates and judicial officials that set conditions for release would have done in the past. Now they won't be able to do that. And so it's limited their ability, which will now allow have a secondary effect, which is you're not allowing them to hear certain cases. Anything that's violent, you can't hear. So now these violent cases will be heard by a district court judge. Well, now those district court judges, their dockets will probably triple. And our jails will sit there and become overcrowded because of this scenario that was a rush, quick attempt to fix a solution where, yes, there were some things that went wrong, but I'm not sure if that portion of it went wrong.
Governor Stein supports this new legislation going forward, as many do, trying to, this reactive type of legislation that's trying to fix these issues. If, in your opinion, what would you do?
What I'd say is have proper funding for training. I do believe that in our state, magistrates should have a law degree. So that's something that's not required. So that's something that if you're going to require that they have a law degree, take the funding that you're going to throw at having more district attorneys, ensure that you have proper funding to pay adequately people that would have a law degree. The reason why you have folks that don't have a law degree becoming magistrates because the pay is not appropriate for someone that's went to law school and has a six figures worth of debt. If you're attempting to pay someone $60,000, $65,000, most folks aren't jumping at that because you can make that at Amazon warehouse, without a law degree. Those are the types of things that if you start saying we want to have people to have legal training, you have that. Because when you become a magistrate, they send you to magistrate school. That's 2 weeks in Raleigh in UNC Chapel Hill, I should say, at the School of Government. But it's not law school. So not having that legal and analytical thinking, that thought process that you learn in law school, it definitely helps to have that. And so I can see, if you ask what would I do different, I'd ensure that all magistrates are attorneys and that they have the training that's necessary to do these types of things and the funding and money to support it. So I wouldn't get more DAs. I'd get more magistrates that are licensed attorneys.
Okay. And then as far as internally here in the city of Charlotte, we're going to see a little bit more security on CAT's public safety as we're going forward, trying to create a much safer situation as far as public transit and also for fare enforcement as well.
Well, what I can tell you, Brian, is that the job of a judge when you are making determination is the question of do I detain or do I release, right? So what also is wrapped up in here is this rebuttable presumption. There's a rebuttable presumption now that every time it's a violent crime, that no bond could be set to keep the public safe. That is a major change. So now, even if you wanted to let them out as a magistrate or as a district court judge, you can't unless now they can overcome that rebuttable presumption. And I say they, the impacts on the due process will be this. There's not an attorney arguing for them in front of the magistrate. They're going to be standing there as a lay person attempting to figure out how they can maneuver the system to say, there's no rebuttable presumption, I should be out. But you won't be able to overcome that because you don't have the legal training. So now you have a non-attorney magistrate listening to the case and a non-attorney defendant trying to figure out how you can overcome the rebuttable presumption that's hanging over the magistrate's head before they can decide to release on these type of crimes. And it's limited amount of violent crimes that they can look at. So I think that safety is at the forefront of everyone's mind, but we also got to remember what due process looks like. Remembering that everyone that is charged with a crime is innocent till proven guilty. Yes, this one scenario right here is the most horrific thing you could ever imagine, but it's not the norm. These type of scenarios don't happen all the time. And so now what we have is we create a law that's going to have all the time impacts with a one-off scenario.
We have certainly seen a lot of disturbing incidents that have happened in Uptown recently. One of those, it's been kind of put Charlotte in this national spotlight, obviously with the light rail stabbing from 1 month ago. But on Friday of last week or Thursday of last week, we had a shooting in Uptown. And that was where we got some surveillance video of that. The guy claimed some self-defense. We're going to talk about that law, the stand your ground law, as also how it relates to the surveillance video that we did see and what CMPD is charging with that guy. And we'll have more on that coming up after the break. You're watching Queen City News Plus, in Order on the Court with Khalif and Brian. Welcome back to Order on the Court on Queen City News Plus. You're with Khalif and Brian right now, and we're talking about our second segment today. Another disturbing incident happened in Uptown in the afternoon, about 1:30 in the afternoon, over in a very popular area, Ladder Court, the arcade there on Brevard Court in Uptown across from Romare Bearden Park, where a young man was shot to death. And then they made the arrest following that. But just a disturbing situation for a lot of folks there in that area where there's a lot of business people there. There's a lot of people roaming around as far as tourists and checking out everything. There's restaurants. But here someone comes and pulls out a gun and then shoot somebody in broad daylight, and that person did die. But there's a lot of circumstances surrounding that shooting where the person is claiming self-defense. And so the CMPD says, Khalif, that they believe that there is reason to charge him, but he is saying self-defense because the suspect or the victim here initiated the contact and punched the suspect here first.
This is a lot to unpack, Brian. I'll try to do my best. So North Carolina has, well, before we get to that portion, you bring up self-defense. You can have self-defense. You can have defense of others. Self-defense extends to...
Now, here's the video right here as we're watching.
Right. So self-defense is something
yeah.
that I believe, and the key word is that imminent fear of bodily harm is going to occur. So in this scenario that you describe and looking at the video, this individual was not just in imminent fear of bodily harm. He was harmed, assaulted, pushed, punched, multiple times before this individual decided to defend himself. Now, you have to break these types of things down. You talk about, okay, we have enough evidence to charge him with a homicide. So now we would probably bring up stand your ground, which is in our statute encompasses a lot of self-defense. And it's a couple of things. First, you have no duty to retreat. So if you're attempting to attack me, I don't have to run and flee from you because I'm scared to get killed, and then I can protect myself then. I can stand where I'm at, and if you're attempting to hurt me, assault me, threaten me, I can then protect myself.
Suspect right here stayed at the scene afterwards.
And it would be helpful to his case. Staying at the scene lets me know, hey, I didn't try to flee. I wasn't running. I thought this man was genuinely going to kill me. And I'm in a place that I'm lawfully allowed to be. So I can't have a stand your own ground if I'm uninvited at your house. But I can have stand your own ground if I'm standing outside on a public sidewalk. If I'm in a restaurant frequenting that they haven't kicked me out of, then yes. So you got two of them. No duty to retreat, lawfully present, and then you reasonably believe. This is the key part. You reasonably believe that use of force was necessary, that it was necessary to prevent imminent death. So that's not that, hey, later, as a Monday morning quarterback, me and you are looking at the video and we're like, hey, he had time to not shoot him. He shouldn't have done it so many times. Well, did that reasonable person, not him, but the reasonable person, this mythical person believe that in that similar situation, that imminent death was upon us? And if so, I believe that he would have a defense. So now you say, well, if he got all that, why did he get arrested, right? The officers are going to say, if I think it's a clear-cut case of self-defense, we're not even going to arrest. It will be a bar. We're going to stop it. But if we think even remotely that the defense may be something called imperfect self-defense, where there's holes within this defense, then, yeah, they'll arrest and they'll let the defense attorney argue self-defense as a negotiation tool or at trial. So that stand your ground should be a bar from him even being charged. But if the officers believe that there are other things at play, they'll still charge. That's what happened.
The things where you're talking about, the at play. Detectives said that Jackson, the suspect here, feared for his life, quote. However, based on the footage, police said Jackson continued to approach and shoot Humphrey after being punched, raising concerns about whether his actions were truly in self-defense.
Yeah, see, for me, I as the criminal defense attorney, it'd have to be more of a cooling off period. It'd have to been, I was assaulted, I sat down for 10 minutes, and then I went and got my gun and started walking towards you to shoot you. I think that's clear, not self-defense. But if you've assaulted me, I pull my gun out, and in that same continuing event, I walk towards you shooting you, I think you're still in self-defense. I think that's still within that stand your ground. It doesn't say you can't move forward. It just says you don't have a duty to retreat. So if I am believing that this guy's going to try to hurt me or harm me or kill me, I don't have to walk backwards. The argument will be, did I now shift to the aggressor? Did the altercation stop enough? Did it pause enough? Was there enough delay between the time I was assaulted and the time that I killed him? And if that time was a delay enough, then yes, now I can't claim the argument.
That doesn't seem so black and white, though. How do
it's
you
not.
That,
that's why
the period in between. What is that? And how do you say which is what?
It's not, and that's why they charged him. Because if it was clear, like if it was like, hey, 4 minutes and 30 seconds, that's the time frame where it's now cooling off. It's not enough. Then the officers would have said, all right, we looked at the clock. He had enough time to cool off. We're not charged him. It's not. It's more of a gray area. And these are going to be gray area calls. These are bang scenarios. I had a case just like this last year or 2 years ago where the young man was approaching my client with a firearm. And my client defended himself with his firearm. But it happened in a couple seconds. And the officers are like, well, was it self-defense? Did he instigate this? Maybe it could have went a different way. But most of these type of homicides will be bang, where it's like, you can Monday morning quarterback because we can slow this down, look at it in, the slowest amount of time to decide what he could have done or should have done. But in real time, what would a reasonable person have done? That's what the standard is.
It is certainly another case of where Charlotte has been put in the spotlight here for violence in Uptown. We have seen, though, that this happens quite frequently, probably once or twice a week in Charlotte. But it is now, the microscope is so much greater on Charlotte.
The microscope is greater, but people got to put it in the context. Well, you're the 17th, 18th largest city in the country. crime proportionate to the size of our city is low compared to places like, Chicago or Philadelphia or New York,
Baltimore, Memphis, St.
Baltimore,
Louis.
those locations. We are nowhere near their murder rate. We're nowhere near their violent crime rate. We're nowhere near their juvenile crime rate. Those are places, and even when you most recently had the back and forth with the elected officials on the Democratic and Republican side, trying to say, well, per capita, it's actually these states that are the red states that are having, more of the crime, not the urban areas. If you look at the raw numbers, percentages based on how many people they have based on per crime. And so for our city our size, Charlotte is doing a great job of attempting to combat crime, to ensure that the community is safe. But when you have a scenario like this, to your point, Brian, it brings a microscope. And so now you're not looking at the numbers up here. You're looking at them way down here. You want to get a close-up view to what the numbers look like.
All right, we're going to leave that one there, and we're going to switch gears coming up here in just a second on Order in the Court with Khalif and Brian. We're going to be talking football and a young man's future that was left in the doubt. So we'll be right back. You're watching Order in the Court. All right, welcome back to Order in the Court with Khalif and Brian. Just during the break there, Khalif sitting there doing some legal work, trying to get some, what are we getting done there?
clients, and more clients, which I'm not mad at all. Continue to call, text, or email.
That's great. Hey, always working.
What, like
always
and subscribe is what they say on YouTube. Hey, I am like and subscribe all day. But no, the job never fails. That's all.
Yeah, it was funny. Like during that short, a little bit of downtime right there, he was getting it done. All right, our last topic of the day here for Order in the Court, Queen City News Plus. Khalif, Mitchell Mays, a lineman at UNC Charlotte, a judge ruled that he will not be eligible.
Judge ruled a couple things. Hasn't got to that portion yet. What happens is this guy filed a complaint against the NCAA because they ruled against him. Mm-hmm. So the NCAA, we got 5 years of eligibility, and you can play those 4 years within a 5-year time frame. And we're familiar, if you're a sports fan, with the redshirt year. Well, a redshirt year you can play games in that year, but there's a threshold. The issue with this young man's case is 2021, 2021, he played one more game than he was supposed to. And his coach should have known that. So your coach has an obligation and responsibility to preserve your redshirt year. He didn't. Goes into the game, ends up now triggering a loss of an entire year. So he asked the NCAA to allow him to waive and get an extra year. They denied it. He brings his claim. So then throughout the process, he's now filed an injunction, a temporary restraining order, or TRO, asking that, hey, judge, while you make a determination and wait to make a decision on how or if I get a year back, I want to be able to play now, And in the standard, I've said it on here a number of times. To get a TRO, it's a couple things. You got 4 points. Likelihood of success on the merits, irreparable harm, balancing of the equities, and the public policy. The judge said in this case that he felt that irreparable harm was not proven. And because irreparable harm was not proven, that he would not grant a TRO. The TRO would have given him an opportunity to say, I can dress for the game, I can be a part of the team, and then we can handle the dispute later. Irreparable harm, though, says it's something that money can't fix. And so I didn't look at the other points that the judge, agreed or didn't agree with, but I disagree with his ruling on the irreparable harm. You can't pay me money for missing my last season of eligibility. It's not like I can still be athletic as I was when I was in my 20s at 40-plus years old.
Also, it hurts his chances of any NFL type of situation.
Any NFL situation, any NIL type of money.
NIL?
This has a massive impact. Now, the sad part is the NFL aspect in the NIL, yes, money could fix that. If you were projected to be a first-round pick, if you were projected to have, millions of dollars in NIL, you could sue for those lost revenue and that lost potential. But again, you can't get back the years of health. You can't get back the years of being in shape to be able to play during that time frame. And because of that, money can't fix that. You can't put a dollar symbol on, I missed my senior year of 2025, 2026. That's going to be why I thought the judge would have granted the TRO and allowed this to be, decided later on its merits. But unfortunately, the judge didn't see it that way. Right here in North Carolina, right down the street, Western District of North Carolina made this decision. This is UNC Charlotte right here in our neck of the woods. And it's it's troubling when you see that young man smiling to know that a mistake, not some off-the-field issue, not something that happened that stopped him, but the NCAA has made a number of exceptions during COVID. They granted folks an additional year just because of COVID. Yeah, a lot of seasons were canceled.
A lot of playing 6 years, 7 years.
Right. I mean, look at Carter Starachi with Penn State. He won that 5th national championship. Why? Because he had an extra year of COVID. Those are the types of things that I think the NCAA should have considered when making this determination, and that it wasn't something that he was doing malicious or fraudulent. He didn't lose his eligibility because he was trying to skate the rules. It was an error, an honest mistake. You think an honest mistake.
And a lot of coaches are trying to – there's a lot of assistant coaches that track these type of things during games. They sit there and try to help and protect the player.
Somebody dropped the ball.
Yeah.
Somebody dropped the ball. And now –
interesting that you brought up Penn State. You're right.
Hey, Penn State. We are. You got to represent Penn State.
You got your Penn State colors on.
Hey, that was not intentional, but go Lions. But seriously, I really feel for this young man. But this is the legal process working its way out. He still ultimately, I think, can prevail in this case, but the season will be lost. So then now what do you go and say, we'll grant you an extra year in 2026, 2027? I mean, stay in shape, stay prepared, stay ready. But the likelihood of that happening is slim to none.
Well, we wish him the best and certainly hope we'll be following him and looking forward to good things coming from Mitchell Mays out of UNC Charlotte, and he'll prevail in the ways that he wants to, the best way possible. And thanks for watching here on Order in the Court. You've been watching us today with Khalif and Brian, and we now turn you to Queen City News Plus.
Queen City News Plus. Just search Queen City News on your smart TV's app store.